Everyone, thanks for joining us for today's post-election webinar series focusing on intellectual property. I am Justin Pierce, the co-chair of IP Division at Venable, and accompanied on this presentation by William Nordwin and Nick Choate of our legislative group. William Nordwin's a partner in the legislative group, and Nick Choate, a senior policy advisor. Today, in light of the recent election and recent election results, we're going to go over how our thoughts and how our thinking is with respect to policy post the election, particularly with respect to intellectual property and key issues in IP and intellectual property that we see emerging and playing out over the next 4 years. One thing's for sure, as we look at the difference between the past administration and what we believe to be the current or future administration with Vice President or now President-elect Biden, is that I think with respect to IP, you'll see two major themes. Intellectual property is typically seen, at least by the Biden administration and those supporting its policy, as a tool for trade enforcement. It's something that intellectual property is always a piece of the global trade framework, and I think you'll see a lot more multinational, multilateral attempts to enforce it as compared to what we've seen over the past 4 years, where there's been more of a focus of bilateral arrangements and negotiations on a one-on-one basis. I think number two, another theme you'll see is intellectual property has a lot of complexity in it. It's something that oftentimes, despite that complexity, our politicians tend to be bipartisan about, do tend to support American innovation on all sides, and where you do see divisions, it often happens to be along industry or sector divisions as opposed to large divisions or acrimony between the political parties. And without further ado, I'll turn it to my colleagues here, William and Nick.
Great. Hey, everybody, this is Will Nordwind, co-chair of Venable's Legislative Practice Group. Thanks for joining us today. I'm going to go very quickly through this slide, which is really the results of the 2020 presidential election, and I'm sure for most of you are following this very closely anyway, so don't need to spend a ton of time going over it. But to maybe state the obvious, President-elect Biden has been declared as the projected winner with 290 electoral college votes. President Trump has 232, but has, as you all probably know, yet to concede. So we are still waiting for an official transition to occur, but right now things seem to be trending in the declarations for a President-elect Biden to take office on January 20th. But having said that, Georgia is undergoing an audit. I think the results should be done today and certified at least this week. And yet President Trump continues legal challenges in several states, although those appear to be winding down. So again, we're all major news outlets and the Associated Press have declared President-elect Biden the winner. With that, I'm going to turn it over to Nick Choate to talk about the Senate. Nick?
Thanks, Will. So on the to the extent there's mostly certainty on the presidential front, little uncertainty still remains in the Senate. As it stands today, Republicans have secured 50 seats in going into the next Congress, and Democrats have 48. Both of the Senate races in Georgia, Senator Perdue and Senator Loeffler, their races are both going to runoffs in January. And those races will ultimately determine control of the Senate. If Republicans win just one of those, that will put them at a 51-seat majority, possibly 52 if they win both. Should Democrats pick up both, the Senate will split 50-50, and Vice President-elect Kamala Harris would be the tiebreaker in a Senate, effectively giving Democrats control. I think for the purposes of today's conversation, you'll probably hear us assume that Republicans are going to retain a slight edge in the Senate. Certainly not ruling out the possibility that Democrats could take the chamber, but just given the political dynamics in Georgia and where prognosticators are projecting those races will come out, that seems to be the smart money right now. And not reflected on this slide here, but it's worth touching on the House as well. Democrats retain their House majority. There are still a handful of uncalled House races. The Democratic majority in the House will be smaller in the new year than it has been in this past Congress. Probably looking at somewhere around a 6 or 7 seat majority for the Democrats, combined with a narrower majority for Republicans in the Senate. So Justin touched on this at the top, but we will have a very narrowly divided government. So then where does that put us over the next 60 days? Obviously, there are House races to be called, runoffs in Georgia, and the presidential race still to be called in Georgia. Given deadlines that states have, we think the presidential race will largely be settled by early to mid-December. That's not to say we necessarily expect a formal concession by then, but states will have to certify, and many states have already started doing that. We'll see the Georgia runoffs on January 5th, so we will know pretty quickly, certainly before inauguration, where things stand in the Senate. There are a few things that have to get done before then, however. The government funding bill only runs through December 11th. So one way or another, Congress and the president have to find a way to continue that funding either for a short period of time or to the end of the fiscal year next September. There is continued talk about a new COVID bill. I think conventional wisdom at this point is that probably slips into early next year and is something that the new Congress and the new administration tackle. But there is still a glimmer of hope that COVID could get done before then. And then the big variable, and not to sound partisan about it, I'm a Democrat, but I think any Republican colleague of mine would say the same thing. It is very much an open question as to what the president will be willing to sign between now and inauguration day, up to and including a government funding bill. Of course, Congress could, if they have the votes, override a veto on any of those things, but that is very much a variable we are dealing with for the next 60 days. And on that, Will, I'll tip it back to you to talk about what we know about key leadership positions.
Great. Thanks, Nick. So in the 117th Congress, as Nick mentioned, we do know that the Democrats retain control of the House. And as a result, in terms of the leadership of the chamber, Speaker Pelosi will be at the helm on the Democratic side, and Congressman McCarthy will continue to be the Republican leader in the House. For purposes of intellectual property, most of the issues of relevance fall within the jurisdiction of the judiciary committees in the House and Senate. And in the House, the current chairman, Jerry Nadler of New York, will continue to be the chair in the next Congress, and the current ranking Republican member, Jim Jordan, will continue in that post as well in the next Congress. On the Senate side, as Nick has just mentioned, while there may be smart money that the Republicans will retain a slim majority, it is still an open question due to the two Georgia runoffs in January 5th. So the Republican leader will be Senator McConnell of Kentucky, and the Democratic leader will be Senator Chuck Schumer of New York. And just depends who will be the majority and the minority. And again, we'll know after the January 5th runoff. On the Senate Judiciary Committee, again, having jurisdiction over most intellectual property issues, it is dependent on who is in the majority and as to who the Republican leader of the committee will be. If the Republicans retain the majority in the committee, then Senator Grassley of Iowa will be the chair of that committee. He will take over that leadership post from Senator Lindsey Graham of South Carolina. Senator Graham is term limited by party rules as chairman of that committee, and therefore he would have to, if the Republicans retain the majority, cycle off and give the gavel back to Senator Grassley, who would have 2 more years left to serve out of a term limit of 6 as chairman. So if the Republicans retain control of the Senate, Grassley will be the chairman, and Senator Feinstein would be the ranking Democratic member. On the other hand, if the Democrats were to retain control of, or to get control of the majority in the Senate, then Senator Feinstein would become the chair, and Senator Lindsey Graham would stay on as the top Republican as the ranking member because he would still have 2 more years as the ranking Republican to serve under party rules. So it just depends on who will take the majority, but the folks you see there will be in the leadership roles depending on who retains or takes the majority, and we'll know that at the end of January 5th after the Georgia runoff. So with that, I will turn it over to my colleagues to talk about IP issues to watch coming up in the next year in the next Congress.
And one point here, just before we dive into that, I want to make a note here, as this is a CLE seminar. The CLE code for today is Intellectual Property 2020.
Thanks, Justin. So as you see on the slide here, I think Justin's comments at the top were very accurate. That we are likely to see some significant changes on IP issues due to this change in administration, but it is worth underscoring a lot of IP issues tend to be nonpartisan. They often divide along other lines. So first on our list here is prescription drug pricing reforms is something to continue to watch. I think we would be talking about this regardless of how the election had gone. There continues to be pretty broad bipartisan support in Congress for doing something on this issue. The devil is in the details, and I'm of the view that it will come down to presidential leadership and how high of a priority this is. But you have bipartisan support in the House, to some degree bipartisan support in the Senate. There is a change in chairmanships at the Senate Finance Committee, which has jurisdiction over this issue, with Grassley going back to Judiciary. Senator Crapo from Idaho will take over the Finance Committee, so that will be a dynamic to deal with, but very much an issue to continue watching. I think in the healthcare space generally, beyond IP, this probably rises to the top of the list of potential for congressional action. Justin, do you have anything to add on that?
Yes, I do, and I think your comments there are well stated here. I think we're early on, and it's tough to tell. The things that we're certain about is that drug pricing and drug pricing reform is a key issue. If you really look hard at the platforms of both major political parties, both the Republicans and Democrats, in different ways, you saw it manifest itself during the election season, even if you think back to certain campaign ads. But there really is a certain level of bipartisan support to do something in this area. And what that something is, obviously there can be a lot of details to it. The something that I think will be agreed upon at some level is on pricing. A lot of times one might say pricing should be separate from any analysis on patents, but it could have an impact in the following ways. I think with the focus on pricing, many folks will look at, and many quarters will look at, what are all the different levers we can push to lower the pricing of a drug and how it's delivered and used with patients. And so obviously patents can become part of that discussion, where the supply of drugs come from, whether it's generics, whether it's branded, will also be part of that discussion. I think in terms of improving the supply of generics and maybe quality, so-called quality generics, I think that's a discussion that will continue to happen and can be continued at least to be entered into on both sides. I think there'll be a push on the Democratic or on the Biden administration side because they do have, to use a political term, a big tent with a lot of different quarters. And if you pay attention to some of the different recommendations that have come out of the Biden-Sanders Unity Task Force, there are recommendations that go to drug pricing. And there have been some concerns voiced by different critics, even of Biden, who oftentimes by some of his critics has been viewed as big pharma or big pharma supportive, that he or others should look into concepts like evergreening. Evergreening is a term you may hear thrown around where certain critics will say that patents have their lives being extended artificially. You'll have others clearly on the other side that say, look, you need innovation, you need something to remunerate or incentivize those who are in the patent field. So evergreening is something where I think you'll see some criticisms in terms of whether or not laws, or at least looks into the laws to whether a law supports actual innovation versus evergreening, the extension of a patent, maybe for minor improvements. But just as hard as people argue on that side, you'll see some pretty strong arguments. And I think part of the debate and policy thought process that the Biden administration will get into is sort of which levers to push when it comes to innovation and what do you incentivize such that new drugs and major developments still happen in the pharmaceutical world. Last but not least, I do want to say that I think with respect to some of the provisions that are looked at in the law that come down to patents, there'll be also aspects of this that are international in terms of where the drug supply comes from and in terms of the quality of drugs. And so I think those are areas, whether it's incoming generics from outside the U.S., I think there'll be a lot of focus and a lot of intensity on the quality of that. And then I think there'll also be a real big push internationally. A lot of people may not be aware of this, but in China, there was a recent major change of their patent law, where the patent laws are updated and will have significant impacts, particularly for those who own patents in China, and how it will impact the world of pharmaceutical drug patenting there. Obviously, we're all interconnected in ways that we've all gotten to realize, many of us personally over the past year, and I think that's something that'll continue to be an area of focus.
Thanks, Justin. On this next bullet here, obviously, headlines out there, everyone is aware there's a Supreme Court case right now, California v. Texas, again, trying to strike down the Affordable Care Act, specifically over the individual mandate and whether that is severable from the rest of the law. I think there is some optimism among Democrats, at least, that based on the oral arguments, the court does not appear to be inclined to strike down the entire law, and with it the Biologics Price Competition and Innovation Act. However, I would just note here that in a scenario where the Affordable Care Act were knocked down in its entirety, healthcare becomes a very dicey issue in a divided Congress. There are certainly aspects, including the biologics piece here, where there's broad bipartisan support to do something. But the concern then becomes, do the bipartisan consensus pieces of it get held up by the controversial pieces? I think the best analogy I have here is on immigration issues. There are obviously a number of bipartisan things there, but they can't get done because of the more controversial pieces of that issue. So we'll get a decision this spring, early summer on this and have more certainty. But this is certainly one to watch in the IP space as well. And Justin, do you have anything to add there?
Yeah, I think there really just 2 points. I think obviously we're in a very divided world politically when it comes to issues like ACA. I think for the promise and at least the aims of the provisions dealing with biologics, the BCPA innovate, the BPCIA, that's something that regardless of whether the baby is thrown out with the bathwater, I think there will be an effort. Now, who knows whether the effort ultimately would be successful, but I think there would be a strong effort that even if the baby's thrown out with the bathwater, that some legislative fix would happen thereafter, such that from a practical measure, much of the promise, or at least the provisions of the Biologics Price Competition Act, would still be in place, or at least hope to be in place.
Yeah, I think that's a fair assessment.
Okay, so next I think we've got here China IP theft. That is definitely an issue that's probably subsumed in some of the issues we talked about earlier in just the framework of what is being done to protect American innovation and American IP around the world. There's a lot of talk during the election, and probably still will be, where there's a lot of saber rattling over what's happening specifically with IP rights for U.S. companies doing business in China or dealing with China. Some of that is saber rattling. Some of that is the kind of thing where I think there just has to be a lot more focus on what actual protections and what actual steps companies take. I think there's a piece of that that even relates to education that needs to happen. And in terms of where we think the administration, the Biden administration, will go in the future with that, is we think IP enforcement really will be looked at through a lens of enforcing rights through foreign or global trade policy. In essence, trade enforcement, one of the ways to get better trade enforcement or better trade deals is to use different IP enforcement or IP provisions as levers. Two things I think will happen going forward that we can look to. One, we talked about this sort of push towards multilateral efforts as opposed to bilateral efforts. That really, in plain speak, means that I think there'll be more of a focus on treaties or different multi-party alliances. Think of things maybe like the TPP. It may not be the TPP or Trans-Pacific Partnership that was contemplated around 2015, 2016, but things like that, where there's a real attempt by the Biden administration to use sort of the traditional channels of diplomacy to pull together trade blocs and to push harmonization of different international IP laws so that it makes it easier to have a group of companies that are following similar, a group of countries that are following similar IP laws and with similar values in terms of protection of IP to get where you want to be. I think two practical areas where you'll see focus on protection of IP will probably be in areas relating to 5G. I think you'll also see it in areas relating to biotechnology as well. Nick, any
Thanks,
additional
Justin.
thoughts there? Yeah, okay.
Oh, no, not from me on that.
Okay.
I was going to just take the next one here, standard essential patents, and we're starting to see some interest on Capitol Hill with respect to the Trump administration's antitrust division, Justice Department antitrust division perspective on where the intersection between antitrust law and standard essential patents lies, and the involvement of antitrust law in the question of standard essential patent pools and their licensing behavior, whether it's in terms of who to whom pools for standard essential patents license, to whom they license, and also the rates and whether they are indeed FRAND, fair, reasonable, and non-discriminatory. And we've seen at least some concerns that the Trump administration's antitrust division has taken somewhat of an opposite tack of the Obama administration and previous Republican administrations on that, and that has caused some concern, but also there is some support for that on Capitol Hill, and it appears in both instances to be bipartisan. So we may see with the new administration or the new antitrust division, Assistant Attorney General for Antitrust, some activity around that issue and a potential return to pre-Trump era policy on that remains to be seen. And Justin, I think you had some potential other observations around that as well.
Yep, absolutely. Thank you. So I think when it comes to standard essential patents, that's something that's sort of here to stay and certainly going to be more impactful in the world as we go forward. If you think about standard essential patents, those are really patents that are part of or cornerstone to an interoperability standard is one way to look at it. And I think, if we back away from some of the, we're looking at things here legislatively, obviously, and which way things will go in terms of the next 4 years. But I think standard setting organizations or SSOs will play a big part of this. I think this is an area where the government has to work with business and industry in every key technology sector. And when you go to the experts or those who have technical knowledge in a particular field, one of the themes and one of the things that is key to there being advancement, meaning a number of people or consumers adopting a new technology and having sort of a similar standard so that you're not running around having to get multiple licenses from multiple different industry players and a certain level of efficiency. That's something that you do need to have technology build in any society, in any group. And I think as a result of that, you're going to see a lot of focus in this area about just how to keep things efficient, how to keep things from being anti-competitive, and how to keep things from resulting in an area where the patent monopoly may be inures to the benefit of one as opposed to inures to the benefit of people being able to have some predictable growth and advancement in certain industries going forward. I think those are values that I believe the Biden administration, following probably some of the lead in its experience during the time that Biden was vice president, will probably continue some of those policies going forward.
So then some other IP issues to watch as we continue here. Covered business method patent review resurrection. We put that as a question mark. As some of you may know, the covered business method review process was implemented by the American Invents Act, but sunsetted on September 16th of this year. We've detected some interest on the part of those who would like to see that program extended and reauthorized. So we may see some effort along those lines. There had been some in fits and starts over the last couple years, effort to extend it, but didn't really gain much traction. But now that it's actually sunsetted, I think there's some interest in seeing how the absence of the review program is affecting patent stakeholders and determine whether or not there's any interest in expanding that into the future. Justin, I think I'll turn it over to you to hit the next one.
Right. So two things here. I did want to follow up just on the covered business method patent resurrection. I think just from an industry standpoint, we have not seen, as William put up there, a lot of groundswell for sort of keeping that in position, which we thought was interesting. Obviously, we'll keep our ears to the ground on that. Then going forward here is a big bullet here on this next slide dealing with sort of the rise of e-commerce and anti-counterfeiting legislation to protect consumers and brands. That's important because that's really part of the theme we kicked this off with, that there are a lot of aspects of IP that are global in nature and global more so than they've probably ever been before in our history. And this is yet another manifestation of that. Obviously, throughout the time of COVID and the time of dealing with stay-at-home orders, e-commerce shopping, we don't have to sort of run through some of the surveys and data on that, but I think probably most of you instinctively know that e-commerce shopping and e-commerce has just risen to prominence, even more so than the fast uptake it was already having in modern society. Now it's obviously here to stay. People are ordering more goods of all types than ever before, from consumer to business to conducting business online in ways that they just haven't done at a huge scale. Naturally, because of that rise in commerce, there has been an uptick in unscrupulous providers of products and services, and an uptick in e-commerce or digital piracy and counterfeiting throughout the world. Obviously, that has a huge impact on American consumers who process and purchase a huge amount of the world's percentage of consumer goods and brands through e-commerce. Obviously, the legislature and really politicians on both sides have been made aware of just how important this is, and I think there's been a lot of efforts in the recent year to look at ways to hold e-commerce platforms to some tougher standards when it comes to issues like contributory liability, and really going towards goals of keeping their platforms as clear as they possibly can and taking a bit more responsibility for policing their own platforms so that consumers are less likely to buy unsafe, dangerous, or counterfeit goods. Some of the different pieces of legislation that are out there pending are listed here. The SANTA Act, Shop Safe Act, and Informed Consumers Act. What's interesting, we'll go into some of these, obviously with some detail from Nick, but what's interesting about all of these is that there are a couple of different aspects that they are uniformly asking or sort of demanding from platforms. And a lot of it relates to identifying those third-party sellers and making sure that the platforms require that third-party sellers on these platforms identify themselves so that when or if some harm comes or if infringement on an IP level is occurring, that the IP owner or the consumer who's concerned about safety can actually identify and ascertain who's actually providing and supplying the product. Another issue here that comes up a lot is just requiring the platforms, like I said before, to do a little bit more in policing themselves. So one theme you'll see in some of this legislation is that there'll be provisions that actually say that they should be held contributory liable for IP infringing products or products that have been deemed by, for instance, a court to be IP infringing that are sold on their platforms. With that, I'll turn to Nick for some more detail.
Yeah, thanks, Justin. As you mentioned, a few examples here of bills that have been introduced in the current Congress. It is worth noting that none of these saw action beyond introduction. Committees did not ultimately take these bills up and report them. We had a weird congressional session this past year, especially because of COVID. Congress wasn't really in session. And therefore relatively inactive compared to other years. I think we should look for bills like this to be reintroduced and perhaps greater activity. The other thing I would flag on all of these, it kind of veers into the, beyond IP issues specifically, this kind of veers into the broader debate over tech platform liability. Obviously, that has become a more partisan debate in recent years and certainly recent months, whether it's political speech or hate speech or any number of issues. There's great interest in Congress in looking at assigning greater liability to the various tech platforms. And I think most, if not all, of these bills veer into that territory as well. So as that debate continues, these bills continue to be something to watch as well. And on that, Will, I think I'll kick it over to you for the DMCA bullet.
Yep. So as many of you or some of you may follow, the Digital Millennial Copyright Act has a process by which the Library of Congress or Librarian of Congress does a triennial review to determine whether there should be any exemptions to the anti-circumvention provisions of the Digital Millennial Copyright Act. And it is the Library of Congress is right now in the midst of a triennial review to keep in place existing exemptions it's granted, and then any new exemptions that are requested are subject to further comment and rulemaking that's ongoing right now. So I suspect we'll continue to see additional comments filed through the remainder of this year, and then some decision making coming out of the Library of Congress in early part of next year to set up for the next 3 years what the universe will look like in that regard until the next triennial review. This is the 8th such triennial review since the DMCA was enacted into law. So we'll be following that as well. And then from there, I guess the next issue, we're seeing some activity in Congress as of late is relates to the PTAB discretionary denial issue. And Justin, do you want to tee that one up, and then I'll give a little bit of a sense of where I see things.
Yeah, absolutely. So I think a couple of things going on here. Primarily, the PTAB, and for those who may not know the acronym, that's the Patent Trial and Appeal Board. That's part of the U.S. Patent and Trademark Office that focuses on being able to hold administrative proceedings based on determinations of whether or not a particular patent is valid or invalid. And we're talking about patents generally here in this context that have been issued. Oftentimes you will have a company being sued by, let's say, a plaintiff or someone saying that you're infringing our patents. One of their tools after the American Invents Acts is to, obviously defend yourself in court if you want to go that far, but before going to court, avail yourself of this administrative proceeding called an IPR, an inter partes review, if possible, where you seek the Patent Office or the Patent Trial and Appeal Board's permission, if you will, to institute an IPR review. What happens when they institute one of these IPR reviews is they have the ability then either to, accept your request to institute the proceeding or decline it. If you're able to get it accepted, there's a chance that you might be able to ultimately invalidate the patent that's been asserted against you. Obviously, though, if you're declined and you're not able to get an IPR review instituted, then obviously you've got to defend yourself in court. As you can imagine, patent owners, and in many cases those sometimes pejoratively called patent trolls, are on the side of being able to institute, or on the side of obviously people having these IPRs declined and want the corporate defendant to have to defend itself in court, such that the IPR administrative proceeding doesn't stop this. It's important to note that the Patent and Trade, the USPTO itself has been seeking input on this very issue, and input on from all stakeholders in terms of the factors that are used to, for instance, decline instituting an IPR. And they have been asking this since October 20th, and I think today, November 19th, might be the end of accepting comments on this. And so in particular, they're seeking comments on what happens and thoughts on sort of the factors that are used to deny these IPRs. So it's a very timely and hot issue. And with that, I'll turn it to Will Nordwin.
Yeah, thanks, Justin. And all I'll say on that is we've seen some evidence of different industry groups on different sides, on either side of this issue, urging Congress to do oversight, or in the case of those who think that the discretionary denials are improperly being granted, there's an interest in oversight of the PTO's policies there. And then there is a on the opposite side, those who are urging status quo have also been urging Congress to essentially support the PTO's policies there. So we'll see if there's any additional congressional oversight one way or the other that comes out of that, and to what extent it impacts the comment period and the view of the PTO as to whether it views what it's doing as in need of reform or not. Those who have urged oversight in opposition to discretionary denial policies of the PTO suggest that those discretionary denials fly directly in the face of the legislative intent of the American Invents Act, which created the PTAB in the first place. So we're watching to see evidence of either House or Senate Judiciary Committee leadership or members, rank and file, weighing in one way or the other on that, and we'll be closely following that one. So then the final item on our list is the International Trade Commissioner, ITC's Section 337 reforms, and in particular legislation that's been introduced called the Advancing America's Interests Act. And here is just to sort of tee it up for Justin, we do see some effort to use what is trade policy, which is the International Trade Commission's enforcement of intellectual property through this Section 337 process to exclude infringing items from coming into the United States, from being imported. And this notion that, as Justin said in a previous bullet, sort of pejoratively, the notion that trolls, patent trolls, are using the International Trade Commission Section 337 process in a way that's harmful to competition and to potential innovation. And let me kick it over to Justin to give a little bit more gloss on that, and then I can come back and talk about the legislation that's been introduced.
Right. Thanks, Will. So it's interesting. Section 337 is sort of parlance. It relates to really our U.S. International Trade Commission, which has a court that can hear a number of different cases. Section 337 in this context deals with intellectual property cases. That provision of the statute and what this court really is meant to do is it's basically set up as a mechanism and appropriate to use as a mechanism for U.S. IP owners. In this context, we're talking about patent owners who face competition, for instance, from unscrupulous foreign manufacturers that are operating beyond the jurisdiction, for instance, of U.S. courts. What happens is oftentimes, and what has been happening, is that you've had different entities take advantage, in some cases even entities that are foreign and not U.S., that are essentially patent licensing entities, maybe companies that are not manufacturing goods per se in the U.S., avail themselves of this court to then sue or at least, as they would say, strong-arm U.S. companies, particularly in the tech industry or any type of industry, to pay for patents. What's unique about this court is the remedy here that you get in ITC is not a monetary remedy. It's really the order that you get out of it. The exclusive order is really just stopping trade, the ability to stop importation and get an order eventually through customs, if enforced, where you could stop the sale of the so-called infringing good. So what's unique about this court is to get in it, you basically have to show that you have a domestic industry. It's one of the requirements to even avail yourself to become a plaintiff in this particular court. The argument as it goes here is that patent licensing entities or non-practicing entities or patent trolls don't really have a manufacturing component, or at least a domestic industry in the U.S., and so therefore they should not be able to avail themselves of that court to then use it as a tool in their licensing programs when they could very well just use regular, U.S. federal district courts to advance their cases and seek remuneration for patent infringement that they think they may have. And that's really what's at the heart of this. On the one side, obviously, you've got folks who say, look, for patent licensing entities to be able to use the ITC is a stretch. That's always required domestic industry. On the other hand, you will have the people who support being able to use that as a venue who will say, look, patent licensing is an industry unto itself, and you are just doing something that's unfair and pejorative to those that you call patent trolls. And so with that, I'll turn it back to Will for some additional detail on the legislation.
Yeah, thanks, Justin. And so there has been introduced a bill called the Advancing America's Interest Act. It was introduced this summer by Congresswoman Del Bene, a Democrat, and Congressman Schweikert, a Republican. Because this is an issue that affects the International Trade Commission Act, it's not an issue within the House and Senate, within the House Judiciary Committee, or it actually goes to the House Ways and Means Committee, which has jurisdiction over trade policy. And the bill itself would amend the Section 337 of the ITC Act to make it more difficult for non-practicing entities who, as Justin described, are otherwise sometimes pejoratively known as trolls, to file. It would make it more difficult for those non-practicing entities to file complaints, establish a domestic industry, and then ultimately seek an exclusion order in an ITC Section 337 action. The bill was introduced. It has the two sponsors. There were no additional sponsors, to a point that Nick made. This was kind of an odd year in Congress a very odd year in Congress with COVID. So, it's not clear that there was a lot of effort to try to gain co-sponsors to the legislation. But we are going to watch this carefully to see if it's going to be reintroduced in the next Congress, and to the extent that it gets traction. Again, it's sort of this intersection of the trade policy and the Ways and Means Committee's jurisdiction over potential IP issues or issues that affect intellectual property. So I guess with that, I'll turn it back over to Justin.
Okay, great. I think that concludes at least the formal part of our presentation here today. We want to open it up now for those of you who may have questions or comments on any of the materials that we covered today. All right, we're in the midst of just checking the chat function to see. So far, we don't see any other additional questions yet. We'll hold just for a little bit, just in case that there still are. Before we do address that, I did want to follow up on one last piece of what was mentioned with the ITC 337 reforms, which was covered. In addition to the domestic industry requirement that we talked about there, which is really what I think a lot of the focus has been on, one additional unique aspect of ITC 337 actions is that there's also a factor called public interest. And that's really sort of a catch-all category where parties are basically asked to argue how their claim or defense may or how the case may relate to the public interest of a U.S. entity and its ability to engage in fair trade. So as you might suspect, again, that factor, whether it's domestic industry or U.S. public interest, come into play in a unique way when you're talking about non-practicing entities who don't necessarily make a product in the U.S. And I think also when you look at things from the public interest factor, that's another reason why this legislation or reform here in this aspect caught a lot of attention, because the argument would go, well, if you're just in the patent licensing business, how's that really in the public interest of a domestically based, U.S. business or industry, or how's that protect U.S. trade and manufacturing? And so, again, just another aspect or another way to look at that same controversy. Okay, looks like we have not received any questions that I can see, so I will basically just conclude this by saying thanks again for joining us today. This is a lot of information to cover over some really hot topics that I think we'll see play out in the near and midterm future. We definitely are available to answer questions. Please feel free to reach out to us even independently after this seminar. And we want to thank each and every one of you for attending and listening and joining this webinar today.